You want to reserve any time for rebuttal?
Yes, Your Honor. May it please the court. We'd like to reserve 3 minutes for rebuttal. Also, I want, excuse me,
3 minutes for rebuttal?
well, 5.
How much time do you want for rebuttal?
Pardon me?
How much time do you want for your rebuttal?
3 minutes. You don't have to bear with me. I've got some new hearing aids. Sometimes they work.
I said about the clock until you heard me. If you heard me, I said, you said 3 minutes, I heard 3 minutes.
Yeah,
You ready?
3 minutes it should be
All
fine.
right, you ready to begin? Start the clock.
Yes, Your Honor. For the record, I'm Ernest Marshall, attorney retired. I'm appearing pro se. I represented the decedent of the estate that's involved in these proceedings up until the time that his demise occurred, and also until I had to retire. I had a heart attack in 2015, so I am still tagging along in this case. So
Well, let me ask you a question. Were you removed from this case by the court for that reason or some other reason?
the court removed me or disqualified me because of the motion filed by the former wife. And the removal by me has nothing to do directly with.
But the client didn't ask that you be terminated.
Pardon me?
It had nothing to do with the client's request.
No, I was not asked to be removed by the
So
client.
here's my $64,000 question.
Sure.
You get removed, did you file a motion to lien your fees? Did you ask that the judge determine reasonable hour and amount, or you just let it go until you filed your claim in the estate?
No, in fact, the final judgment reserved all issues of attorney's fees and liens. I have both a motion filed, signed by I and my client. I also filed a charging lien, and this is still pending. It has not been disposed of, unfortunately, after all this time.
But the client passed away.
Client passed away suddenly from COVID back in 2018, I think. I believe that's right. All right.
Okay, and then when you got an objection to the claim, normally people would file either an independent cause of action within 30 days, or they file a motion for extension of time, but you didn't do either of those.
Oh, yes, I did.
You filed a lawsuit.
Yes, a lawsuit was pending at the time for fees, and it's still
Where
pending.
was it pending? Divorce case?
It's in the family law court at this time, and
But
the
you
probate court.
understand my question? My question is, when you file your claim in the estate, they object. Then you file a new lawsuit. You can't say there's one pending. That doesn't work that way. So you need a new lawsuit or a declaratory judgment or something. And my question is, did you do something besides say, I already got a lawsuit, I don't need another one?
Yes, I filed 2 motions that were contained, and it's in the brief, the documents showing that we had asked for an extension of time. I did that within 30 days of the time limit of when you can do that. I did file 2. And both of them, in each case, asked that the proceedings that were going on at the time when the decedent died, and are still going on as we speak
Well,
today.
you filed a motion to strike the objection. This
Yes.
appeal is about the denial of the motion to strike the objection. Is that true or false?
That's true.
So all this other stuff has got nothing to do with why we're here today.
Well, it does, only to the extent that that's why we are here today.
All right, no, I mean, it's interesting, it's background, but it's not the gist of the appeal.
The gist of the appeal is that we are appealing the failure of the lower court to apply the rules of civil procedure for the appeal instead of the appeal rule that's in the probate court. There's 2 rules, and that's what this appeal turns on, is whether or not the lower court was correct in dismissing this claim first, because even notwithstanding we have filed 2 motions requesting an extension of time to complete the ongoing proceedings that were going on at the time the deceased died. And secondly, when the appellee invoked the adversary rule in the probate court, that rule specifically mandatorily requires that any further proceedings that's even in the order that's before the court at today and at the signed by the court below, that all motions that we had were adversary motions, and therefore under the rule we were entitled to proceed with the rules of procedure to complete it, the Florida Rules of Civil Procedure, and not the probate rule of appeal that was being raised by the lower court. It was erroneously construed by the court to be that. They could dismiss the motion because we had not timely filed a notice of appeal. Following the rules of civil procedure, we are entitled to file a motion for rehearing within 10 days of the order, which we did. And also, we have a right to wait until the court rules on it. When it rules on it, it tolls the appeal time until the ruling is held and the ruling is made. And if it's adverse to us, we have 30 days to appeal after that. Under the probate rules, you can't do that. And there appears to be, for lack of a better way to describe it, some conflict could appear there, but it doesn't appear to be true, because if you clearly use the rules of probate, and the first rule of the probate code, which establishes the rule of equity of substance over form, and that the rights of myself as a claim, a substantial claim, cannot be taken away because of any misconstruction of anything in the probate court or proceedings. So we have that to our advantage. It's been cited in the brief of the two briefs of the appellate in this case. And in each instance, the lower court, the whole appeal today turns on the question of whether or not the probate appeal rule applies, or the adversary rule that mandatorily requires, and the court entered an order saying that it was an adversary proceeding and it was invoked by the appellee, that they are then bound, and the lower court is bound to apply the rules of civil procedure. And the civil rule of procedure I've outlined to the court today is the rule of procedure that was followed. We filed a motion for rehearing within 10 days of the order striking the claim. And when the court denied that motion, we filed the appeal within 30 days. So this court has jurisdiction. There's no issue on that, in my opinion, from the standpoint of what has happened. The question of whether or not the court committed error and abused its discretion, it's clear from the record, the evidence that the lower court did it. The lower court simply ignored the meanings and the content of the rule and the adversary proceedings, which very clearly says must. Must is the same thing as shall. If you look it up in the dictionary, they don't even have it must listed in the Black's Law Dictionary, but in standard dictionaries, it says essentially the same thing. It requires compliance with whatever that word is directed toward. So it's like the word shall in most cases and proceedings. We submit to the court that since it was the appellee, the estate, that invoked the asking for a adversary proceeding and invoked the adversary rule, they're bound by their decision. And if that had not been done, and there was an objection to the claim, and there was no proceedings taken up, and there was no pending proceedings going on in the family law case, then possibly that adversary or the appeal rule in the probate court would apply. But it doesn't apply in this case because of what I just argued. So for these reasons, Your Honor, we think the two orders, we're entitled to the protection of the equity rules and the application of the adversary procedural rules to be able to ask this court to reverse those orders so that we can finish this thing up in the court below. Now, also the idea of abuse of discretion, while the courts below may not like the way those two rules are written, and even this court may have some question about the way it's written, the two of them, how they apply in a fact situation like this. Nevertheless, the power to change those rules does not lie in the hands of the lower court. It's in the hands of the Florida Supreme Court or the state legislature to change those rules. The lower court can't go ahead and decide that they're not going to pay attention, in effect, to the rule on the adversary rules that direct that Florida Rules of Civil Procedure can be applied, and say that we've got to use the appellate rule to take an appeal of an order that within 30 days without having given the lower court a chance to correct it. And that's totally contrary to equity and contrary to good common sense to expect that to happen. The procedure that we try to do is expedite the movement of these cases through the court system, not tied up with something that is unreasonable. So this would be my argument. I think the whole key to the case for appeal purposes is which of those two rules apply. And the rule that was invoked is by the appellee, not by the appellant, and therefore we're entitled to have these orders reversed. We request they be reversed, and the court confirmed that the two pleadings that we filed showing an extension of time that was within 30 days of the time requirement to ask for an extension to complete the ongoing litigation in the family law court to address the substantial claim that we had filed. Okay. Did I run out of time?
No, you asked for 3 minutes rebuttal and you got more than that left.
Oh, good, thank you.
Good morning, I'm Robert Walton here on behalf of Hadley and joined by Eric Hadley, personal representative of the estate. And I'm asking that the court would please answer the fundamental question, which is whether this court has jurisdiction to hear.
Let's talk about that just briefly. He's got a final order basically terminating his claim. Is that true or false? We couldn't operate by finality. You got a final thing, we'll take jurisdiction. But if you want to argue, you're free to do that. But how do you argue that it's not a final order that terminated his claim for attorney fees?
Well, Your Honor, I believe there are two final orders, and that the rules specify that two final orders may be appealed under one notice of appeal, so long as they are timely as to each final order, and that is not what happened here.
When you say final order, you're talking about the denial of his motion to strike.
Yes, Your Honor.
Objection.
Yes, entered on July
You're
7th.
saying he never filed his lawsuit within 30 days. He's saying, well, it's one pending in the divorce court. I don't need to file another one. Why double litigate? What do you say to that?
Well, Your Honor, I would say that in looking at the order itself, it specifically references the Florida statute, which Your Honor had asked the question at the outset. Why wasn't there a timely separate claim filed as required by the statutes? There was a statement of claim that was filed. There was an objection to claim that was timely that was followed. And there was never a filing of a separate cause of action. And that's the reason why
Well,
it
what
is
about his
final.
argument? You invoke the rules of civil procedure that changes the time frame somehow. Is that something you want to talk about?
No, I would submit to you that in the event that this court determines that it has jurisdiction, and that even though the two final orders were submitted as a single notice of appeal, and that it was not timely as to the first order, that even looking at the application of the statute, that appellant has included in his brief that it was as if as a non-adversary. He actually objected to the motion to declare the probate proceeding as adversarial to invoke the rules. So he's now saying actually it was a good decision that the court invoked the rule, and that it is actually a very straightforward set of facts, that in order for this appeal to be heard and have the court to have jurisdiction, that he had to have filed timely a notice of appeal as to that first order entered July 7, 2022, because it is an appeal of that order is a final order. It's the nature of a final order. It was dispositive as to his rights to be able to either maintain his separate action.
So you're saying if a motion for rehearing was pending, it wouldn't matter. His time had already expired.
Yes, Your Honor.
I got you.
But that even if this court determines that the notice of appeal was sufficient, that was attempting to appeal two final orders that denying the motion for reconsideration and rehearing as it relates to the order denying the motion to strike the objection to claim should still be affirmed, because the lower court went through and looked at the facts, applied the law, and very specifically noted that Mr. Marshall, the appellant, was notified of his obligation in the objection to claim, and he failed to. And this is critical. The finding of fact was that and this is on the record on appeal, that Mr. Marshall did not file any action on his claim as required, nor did he request an extension of time to do so. And that's in the court's order denying motion to strike objection to claim. And that order should be affirmed.
Done?
Yes, Your Honor.
Thank you very much. All right, Mr. Marshall, you've got your rebuttal time remaining. You asked for 3 minutes and that's. Yeah. You have that.
In response to counsel's argument, I would suggest to you, he cited a case in this court that's not on point. That case involved a claim filed by a beneficiary against the estate because of the debt that was being paid off by the estate. That case has nothing to do with this case. This case involves a claim filed by a claimant in the estate, not a beneficiary. So it has no relevance to any of the facts in this case. Secondly, the lower court and the briefs and the records show this. Specifically, when was asked what to do about the pending proceedings that were ongoing in the family law court, what was the probate court going to do about that? When it got to the question about how whether or not an extension was needed or whatever. And she says, well, you can go on into the family law court. I'll even sign an order to allow you to do it. This is fine. Would you do that? And she said, yes. And she did. She signed the order saying we could proceed and continue with the proceedings in the family law court. So that's in the record. And secondly, the suggestion that we did not make a request for extensions is not well taken for the reason that there is incited in the brief and clearly and in the record. There were two requests and two different pleadings filed by the appellant requesting, in effect, to finish this case in the family law court that was going before the decedent died, after he died, and when the claim was filed. That was why the claim was filed, to protect the opportunity to do this. So that is what we did. So there's no need to duplicate something that's already done. You don't turn around and file another suit, start all over again when this thing has been going on since 2015, so to speak. Now, the thing that has to be, again, reminded to the court is substance over form. The first rule in the probate court very clearly says that there will not be any decisions, facts, or pleadings that destroy the rights, legitimate rights and claims of people coming before the probate court. So probate court is a court of equity, and a court of equity controls this kind of thing. We're deciding which rule applies. And I've cited and explained to the court in my argument that why it was in our favor, because they invoked the rule, and once they did that, they had to live with it like we did. So we've done everything we should do, and the time for extensions under the argument and the facts in this case was met twice within 30 days of the time limit that cuts that off. If you check the briefs on it very carefully in that record, you'll see them. Thank you very much.
All right, thank you. Thank you, fellas. Good journey back. We'll be in recess.
All rise.
this.